A very good evening, friends, and welcome from Samvad to this session on perspectives on juvenile justice, given the current preoccupations and may I dare say polarization that has taken place even within the mental health fraternity as far as children in conflict with law is concerned. The use of the title Rich Kids and Fast Cars indeed sharply brings to notice the reason and context for which this polarization has taken place. There were divided opinions even when the Nirbhaya episode took place and the 2015 JJ Act came into existence. You will recall then that child rights groups and women's groups were pitted against each other. And there was a whole debate around the issue of preliminary assessment under Section 15 of the JJ Act for children between 16 and 18 who were accused of what is legally defined as a heinous crime. Time went by, controversies, discussions, debates reigned. And then came the Supreme Court judgment on the Varun Chandra Thakur versus Master Bholu, which really spoke about neurodevelopment. It spoke about childhood vulnerability. There were many other court judgments that really spoke about adolescent vulnerability, particularly in the context of children in conflict with law. And then the Pune Porsche incident has really led to polarization again. And I just want to put certain things in perspective for the audience that has gathered today. First, let's understand that the original controversy around children in conflict with law, particularly with Section 15 of the JJ Act, which was really that is there a methodology that would look at assisting in preliminary assessment? Will there not be self-incrimination? Will the right to appeal and many other principles that are enshrined in the Convention of Rights of the Child be met with? And therefore, through several iterations, people working in Samvad now really worked on a methodology that is in keeping with international trends in literatures. Let us acknowledge and recognize that there is enormous amount of international literature on how these kind of assessments are done. So it is specious to say that such methodology and such science does not exist. Also, if we take the perspective of childhood vulnerability and the polarization between children who really come from marginalized circumstances, and in this case, the outrage and what people label as the culture of impunity, because we are dealing with what are labeled as the richy rich and how they get away and no one is accountable and so on. Let's make certain things very clear. Nowhere is one saying that children who come into conflict with law should not be accountable for what they did. What we are saying is that accountability need not be in the adult criminal justice system. Therefore, in principle, we are against the transfer issue. Now, between exceedingly lenient approaches and the provisions that are there in law, and when those are basically circumvented on the one hand, and exceedingly punitive issues on the other, there is a middle path which really looks at the balance of child neurodevelopment, of vulnerability, even for people who come from so-called privileged backgrounds. And we need to understand and appreciate what that vulnerability in the context of privilege actually means. Today's session, then, therefore, is organized for you to understand both what mental health has to say on this account and what the law has to say in this account, and then balance the two to take a perspective that does not vitiate the polarization that has already taken place. We will keep enough time for you to put your questions. We will curate them on chat, and time permitting, in the 90 minutes that we have till the end of the session, address many of the issues, opinions, controversies, differences of opinion, and confusions that may prevail around what is otherwise likely to develop into a contentious situation and really go against what the basic principles of the Juvenile Justice Act are, even for children in conflict with law. To reiterate, there is enough provision in the juvenile justice system to retain these children within the juvenile justice system and provide for them what we believe are restorative, reformative, and rehabilitative forms of justice rather than retributive forms of justice. With these words of introduction, it is my pleasure to introduce you to the technical and operational lead of Samvad first, Sheila Ramaswamy. She will be followed by Shubham Krishnan Bora, who is a policy and law officer, and they will give you both these perspectives, and then we will take comments, questions, discussions, and leading towards the conclusion of this session. Sheila, over to you.
Thank you very much, Dr. Shekhar. Let's dive right in. Shubham, may I request you to... Yeah, thanks. I believe we are all familiar with the recent events as they transpired in this case of rash driving. Next, Shubham. Just to put a couple of facts across as a quick summary, as we know, this kid was the son of a prominent builder. He told the police that his dad knew that he was consuming liquor and that he was driving without a license. The mother said that the CCTV footage was fake, pleaded for her son to be protected, and so on. The father claimed that it wasn't his son, but the driver who was driving the vehicle. The driver was then offered money. And then, of course, there's been in the news a great deal on how both the father and grandfather have been charged with various kinds of offenses, how the mother was arrested on account of swapping her blood samples, etc., to protect her child. Let's first take a child protection and mental health perspective, not just on this issue, but we'll begin with a much broader perspective on children in conflict with the law. I want to present the landscape of protection and mental health vulnerabilities as experienced by these children. Look at some of these. Why are these children actually vulnerable and disempowered? Right? There are several factors that Dr. Shekhar also mentioned. There's the issue of adolescent neurodevelopment, difficult or adverse childhood experiences, mental health risks, marginalization, the criminal justice processes themselves, which can be extremely child exclusive and marginalizing, the culture of child care institutions, and of course, public opinion. We'll say a little bit about each and then dive deeper into this case. Can we? So neurodevelopment, which of course this audience being mostly mental health is familiar with, that the adolescent brain physiology is such that there are socio-emotional systems and cognitive control systems. We also know from a lot of neurodevelopment evidence that the socio-emotional systems develop much faster, leading to increased reward seeking, the need for instant gratification, the tendency for adolescents to be impulsive, susceptible to peer influence, reward seeking, and, to focus on immediate consequences, essentially rewards, as they make their decisions, as opposed to the cognitive control system, which is really responsible for adolescents to be able to control their impulsivity, to make better social judgments, and so on. And this cognitive control system is much slower to develop, developing well after 20, 22, all the way up to the age of 25, really. So way beyond even 18, which then becomes an artificial category that is internationally set as the cutoff for children. Moving on, adverse childhood experiences. Now, adverse childhood experiences, as many of you know, refer to violence, various types of abuse, physical, emotional, sexual abuse, neglect, exposure to parental separation, parental marital conflict, other difficult issues within the family, such as disability or alcohol abuse or substance abuse among the caregivers, primarily the parents and other adult members of the family responsible for looking after children. Incarceration of one parent. Recall that this is a child who comes from a family where both the father and grandfather have been engaged in multiple illegal activities, or allegedly so anyway. So if you look at what the data or the evidence tells us, says a higher number of adverse childhood experiences are actually associated with greater risk of arrest from childhood through late adolescence. And children with ACEs experiences tend to be younger in age when they are first arrested. Child sexual abuse, emotional neglect, domestic violence, these are all predictors often of sex crimes by adolescents. Substance abuse, family dysfunction, incarceration, and so on are predictors of increased vulnerability to criminal behavior. And young people who have experienced childhood trauma have early criminal onset of high impulsivity levels, and are more susceptible to serious violent crime by the age of 18. And of course, what is the mediator here is very obviously the mental health consequences of adverse childhood experiences. So when children have these difficult experiences, they have emotional and behavior problems that essentially lead them into conflict with the law. Let's move on. In general, in our country, not in this case, but in general, we know that most of the children who come in conflict with the law, the ones who come into the juvenile justice system, who are in our childcare institutions, generally come from low socioeconomic strata, from structurally disempowered families. There is evidence to show that they're mostly from scheduled castes and tribes, from religious minorities. So very clearly, these are kids from families who are highly disempowered in general. And this is true in other countries like the United States, where there's an overrepresentation of children of color, Black children, Hispanics, and so on, in their JJ system, right? So we are mirroring a similar marginalization here. Next. Mental health problems, what we know, and there's a lot of evidence on this globally, children in conflict with the law are 3 times more likely to have mental health issues than the average adolescent from the same community. And mental health disorders can significantly impact cognitive and psychosocial capacities, leading to impulsive and antisocial behaviors. Let's look at how. If we look at externalizing disorders like the attention deficit hyperactive disorder or conduct disorder, there are features like hyperactivity, impulsivity, poor risk perception, poor moral reasoning, aggressive behaviors, and so on. A lot of cognitive distortions that go with externalizing disorders, because of which children make, incorrect or socially inappropriate decisions. If you look at internalizing disorders, likewise, like anxiety or depression, post-traumatic stress disorder, all of which could also be consequences of the erstwhile discussed ACEs, There are a lot of issues relating to poor emotional regulation, cognitive distortions. If you take, for example, the Ryan International School case, which the Supreme Court refers to as the Barun Chandra Thakur case, which Shubham will be alluding to a little later in our talk. You recall that this kid actually was about 16, 17 years old in 12th grade, and just days before the examination, really hurt, or rather killed, a 12-year-old in the toilet. And when asked, he said he wanted the exams to be postponed. Now, of course, we didn't see the child, but if we were really to hazard a guess, it's very likely that he had untreated, unresolved, severe anxiety disorder. And to take such an extreme step, to make a decision so bizarre and so extreme, it is evident that his judgment was clouded in all probability by anxiety, possibly other mental health issues, because while many children, many of us have anxiety about exams, this is a pretty extreme way to go. So what really caused it? The answer probably lay in depth mental health assessments that were never really conducted for the court to be able to understand more deeply what the difficulties of this child were. Next. Another huge vulnerability, and I don't think we see this as a vulnerability, is unfavorable public opinion. Friends, I think it's important for us to acknowledge at this point that India, like other countries, adopted the juvenile transfer law largely because of this. Despite all the scientific evidence in the world to the contrary, our legislature did not accept it because of the severe public pressure that came about post the Nirbhaya incident. Now, here are some things that we need to understand about public opinion. And let me also say here that all of us, whether we are mental health professionals or we are judicial personnel or child protection functionaries, at the end of the day, or perhaps even first and foremost, we are also very much a part of the society we live in. We are part of this general public. But at the same time, I think that in our roles as judges, as mental health professionals, as protection workers, it is important to also separate ourselves or at least be conscious of the general public opinion and our role in society and within the general public to sometimes, particularly at critical times like these, really examine, introspect, and see where our views are coming from, what we are telling people, what our interactions with other non-professionals are. The general public are not really concerned with reconciling the interests of justice or proportionate outcomes with rehabilitation. This is something we really deeply need to recognize. They are concerned. They are concerned about stopping crime, reducing delinquency. That's how they tend to view it. They may not always be averse to rehabilitation, but they do tend to be in favor of retribution, which basically means that they believe that adolescents must be punished, that retributive approaches must be taken, because that's the only way adolescents will learn and, be disciplined and grow up to be law-abiding adults. The global literature that Dr. Shekhar referred to does not support this. Retributive approaches do not lead to reformation. Retributive approaches do not deter adolescents from engaging in socially inappropriate activities, in as much as it's tempting to believe that the evidence in many parts of the world does not show it. Indeed, if you look at mental health itself, and you look at our engagement with our child or adolescent clients, particularly children in conflict with the law or children who have serious conduct issues, the very basis of our interaction with these children is a therapeutic relationship and a therapeutic alliance, which essentially is based on warmth and unconditional positive regard, a belief that, there can be ways to engage with the child and bring about behavior transformation. So if we join the general public and take a view that is largely retributive, it is likely that we will lose the battle with our clients, and we will find it difficult to achieve the kind of therapeutic relationship and the alliance that we so critically need in order to be able to work with young people in these very difficult situations. So it may take a lot of work, but I think we really need to introspect on these get tough policies and these notions of adult crime warrants adult time, and consider what our roles are as professionals who engage with non-professionals and the lay public. Next. If we look at the criminal adjudication processes, these are also inherently disempowering for young people, for children and adolescents, because they are premised on concepts of retribution and shame. That is the nature of the law. Now, juvenile transfer laws are an example, really, of retribution in the legal arena. The primary objective of the processes of criminal and adjudication and sanctioning is essentially to invoke a sense of shame so that we inhibit future offending. And I was just telling you how that where young people are concerned, the evidence actually shows that this doesn't work. But the point I'm making is that this is how our laws are designed. Be that as that may, and we cannot change the law. The laws are designed that way for a certain reason in any case. But where children and adolescents are concerned, the question is, what role do mental health professionals play when we have retributive laws of this nature? When we have laws that are inherently retributive and that negatively impact how an offender, including child offenders, are viewed by family, friends, intimate, other relationships, neighbors, employers, if they're, young people. The stigma and discrimination that is introduced in instances like these, and how all of these issues then become a barrier to reintegration into society, barriers to treatment, and indeed to behavior transformation. So look at all the vulnerabilities and the hindrances that children in conflict with the law, young people in conflict with the law are contending with. Yeah. Next. The culture of childcare institutions, where at least for the most part, rich kids don't really go because, well, they are powerful, they're wealthy, and I think we're all aware of some of the unfortunate ways in which governance and justice systems in our country also can work, not always, but sometimes. But a lot of the children who essentially come to childcare institutions are subjected to further retributive treatment. And contrary to what these places should be, I mean, they should be places of healing and reformation. That's the idea of transformation, but they still tend to be places of detention because there isn't enough done in terms of healing and reformation. So again, the question that we have for all of us as mental health professionals is, what are we really doing wherever we are in our districts, in our cities, to change some of these institutional cultures, to offer the kind of healing and transformative assistance that these children so desperately need. Let's now that was the big picture. That's just the background of children in conflict with the law in general. Let's move beyond socioeconomic stereotypes now to look at how we can apply the vulnerability and mental health lens in affluent families, such as the current case that we are referring to. I want to talk a little here, friends, about neglect. There is a great deal of difficulty in recognizing adverse childhood experiences, particularly neglect, in affluent and wealthy families. But the evidence tells us that child abuse and neglect is also very much prevalent in these families. Abuse, for example, and neglect really does not know either money or class or caste. Right? And if you look at the Government of India 2007 study on abuse, I think that will tell you if 50% or more of the population said that they were abused as children, these are children who came from all walks of society, right? So children from affluent families actually suffer maltreatment in less visible ways because they may not be obviously dirty or malnourished, but they may be emotionally neglected. Wealthy families also, remember, have huge amounts of resources, so they're able to send their children to the best schools, keep their children well fed, well clothed, etc. So there is a veneer often of caring, and that's not necessarily true all the way through. And it really hides the kind of psychological and emotional neglect that might be prevalent beneath. There is, of course, the challenge of emotional neglect and how that is defined, which itself makes it very challenging for mental health professionals and child protection functionaries to actually identify protection issues like violence or neglect in affluent families. Child protection agencies generally are not alert to neglectful affluent parents. A classic example or a manifestation of this is how you look at the adoption system in India, and you look at how woefully poor and unscientific the home studies are. When a child is to be given to adoptee parents, in general, you will notice that the child protection system is just looking at, what is the occupation of the parents, or do they, live in a decent house, and do they have the capacity, the money to send a child to school, etc. Very important, all of that. But that's just one aspect. They don't really look deeply into parental marital relationships, the functionality of the family, what kind of emotional environment this family can actually provide to the child. And these are the reasons why adoption actually is failing in very many ways. So that's just an aside, but it really is a clear manifestation of how our mental health and child protection systems are failing to identify neglect in a nuanced fashion. Moving on, let's look next. Yeah. Let's look at what happens in affluent families and what the scientific evidence tells us about affluent parents and parenting. That they often do not spend enough quality time with children. So read attachment issues right there also. Tend to put excessive pressure on their children to be high achievers. Of course, this is not every affluent family. I'm just saying that this is the evidence that exists to say this also happens in many affluent families, right? That these parents could be emotionally disconnected from their children because they work very long hours, leaving their children with paid carers. They tend to have a more relaxed attitude to drug use and sexuality. So, those are the social learnings that children have within the home and family. They may have problems of alcohol and substance use. That is the parents and the family members. Domestic violence, of course, parental marital conflict, and a whole gamut of other issues, right? Next. Look at the issue of privilege and entitlement, which has been, I think, at the core of many angry and outraged discussions in the last 3 weeks in our country in relation to this case. Friends, we can view privilege and entitlement from a judgmental point of view. That is, we can take the tone that, this child had everything, came from such a privileged family, people who have money, etc. This is what their children are like, and so on and so forth. You could also use a vulnerability lens to viewing privilege and entitlement. look at how it becomes a vulnerability for children. When parents come from a position of privilege and entitlement, imagine the kind of role models that they are to their children. Because what happens in these families is the legitimization or the normalization of power-based values, of wealth-based values, right? These are families with access to resources, to information. As a consequence, when parents and family members, adult family members, believe that they can use these for illegal activities or antisocial behaviors, this is what they're modeling to children. So it's a huge vulnerability for children to actually have parents of this nature or family members of this nature. So I think it's important that we look at privilege and entitlement as a vulnerability for a child, and what it has meant for the child's learning and understanding for behavior, for values, and so on. Privilege and entitlement, interestingly, the evidence says, also has consequences for help seeking and intervention. It is reported that it's very difficult to gain knowledge of family histories in situations such as this, to assess neglect or abuse and so on in these very affluent families, because they're resistant to questioning and to probing. They tend to be non-compliant, that they tend to use lawyers and solicitors and so on to challenge the decisions of child protection systems or any helping system that is trying to provide the necessary assistance to children. So we are up against some of these sorts of challenges. And I want to emphasize again, that is the reason why the lens we wear, and therefore the approach that we take to not just the child, but to the family itself, becomes important. It could make or break the treatment for the child. Right. There are, lastly, some individual child factors to consider in affluent families. So children or adolescents from higher socioeconomic status, when they have access, of course, to liquidity, to greater financial resources, the relative cost of substance is low. So higher liquidity and access to financial resources in these children is also associated with substance use, particularly binge drinking. So greater access to alcohol, which can be purchased from pubs, supermarkets, and different places, really. But having said that, once again, this spending power and substance use, which is also part of the problem in the case at hand, needs to be understood in the social context in which it occurs. What it means to this group, this class of young people who are engaging in such activities, and not to forget normative adolescent development and neurodevelopment, which continues to play a role irrespective of the nature of the family or the socioeconomic class that the family is from. And therefore, the other thing to consider, next, are other mental health vulnerabilities that a given child may have, including this child. There could be temperamental and developmental vulnerabilities, emotional and behavioral issues, which of course are consequences of all the ACEs that we mentioned, of the kind of parenting that the child has had, that in turn impacts social judgment and decision making. So whether this child had anxiety, depression, mood disorder, ADHD, it is important, before we jump to conclusions of any sort, to really suss out all these issues, to look for the mental health and protection vulnerabilities, including life skills deficits. So even in situations where there is no significant family history, which is not true, by the way, in this particular case, there could just be life skill deficits. Our schools are not known for providing life skill education. And by that, we mean equipping children with the kind of education that leads to skills in problem solving, decision making, creative thinking, contending with peer pressure, these are the kind of life skills, not just the 3 Rs that, schools are supposed to be engaging in, and we are not known for that. So there are all of these limitations, which then become vulnerabilities, which really become magnified in a case such as this. With that, I'll hand you over to Shubham for some legal perspectives on this case. Shubham, you're on mute.
Yeah. Thank you, Sheila. I think Sheila drew a picture with regards to what vulnerabilities look like in CICLs, in children in conflict with the law, and also with regards to how those vulnerabilities are not exclusive to one socioeconomic strata in this society, right? These are vulnerabilities which in different forms manifest in children, no matter what their socioeconomic strata is, right? Now let us look at the legal aspect of this case, right? With regards to how did the legal system deal with the child and how it is currently dealing with the child. And also with regards to how the juvenile justice law, the Juvenile Justice Act of 2015, actually recognizes these vulnerabilities regardless of socioeconomic of the child, and how that recognition manifests into multiple ways in which we can go ahead and deal with this child, or in fact any other child who comes in conflict with the law, without having to resort to overtly retributive and overtly punitive measures. So the legal actions initially that took place when this boy was apprehended was that initially the boy was charged under 304A of the Indian Penal Code, which is causing death of a person through rash or negligent act. And this is not amounting to culpable homicide, right? Now, initially, bail order was given, and we all know that the conditions under which the bail was given were actually the most instigating factor, which instigated such public outrage among people across the country, right? The fact that he was given to write a 300-word essay on road safety. The boy was asked to visit an RTO, study the rules and regulations of traffic rules and regulations, and give a presentation and work with the traffic police for 15 days, right? So these lenient bail conditions were actually what triggered the public outrage that we see, right? Then the father was apprehended under Section 75 of the Juvenile Justice Act, which is willful neglect of a child or exposing a child to mental or physical illness, which comes under the definition of cruelty to a child, and also under Section 77, which is supplying or causing to supply intoxicating liquor or drugs to a child, right? So he was apprehended initially under that, and also under the Motor Vehicles Act as well, which wherein like if the owner of a vehicle allows another person to drive the vehicle, and that person is not permitted to drive that vehicle, then at that point in time he was also booked under the Motor Vehicles Act, right? Now after that there was a whole witch hunt, and because of which the father was charged with multiple other offenses as well, offenses which he is accused of committing way back in the past as well, right? So which have nothing to do per se with this case in general. Then the pub owner was arrested for giving alcohol to an underage person under Section 77 of the JJ Act, and there was public outrage. The JJB ended up modifying its order and sent him to actually an observation home till June 5th, and then it was extended by a further week, and the current order has remanded him till date, and today probably an order would have been passed to either let him go on bail or looking at the circumstances, probably continue the bail, continue the keeping him in the remand home, right? Now the boy, after this public outrage, what also happened, and after the deputy CM of Maharashtra actually also ended up commenting on the case, what happened is that the police added an additional charge of 304 IPC 304, which is culpable homicide not amounting to murder, right? And now we'll see what these definitions exactly exactly mean, and whether this boy can be charged with 304 or should he be charged instead with 304A, right? So now there are 4 provisions of the IPC which are relevant here, right? Culpable homicide, which is section 299, section 300, which is murder, and 304A, which is causing death by negligence, and 279, which is rash driving or riding on a public way. What we need to keep in mind here is that there is when someone actually kills someone, in legal terms we term it as a homicide, right? We do not really call it a murder because there are specific conditions which have to be fulfilled in order for any form of killing or any form of homicide to be called murder, right? It is so in general, killing is homicide. Now there are certain lawful homicides as well, which are considered legal under the law. For example, and there are other kinds of homicide which are unlawful homicides. Right? Now, under unlawful homicides, culpable homicide there are two kinds of unlawful homicide that we need to keep in mind here. One is murder, section 300, and the other one is culpable homicide not amounting to murder. Right? Now, the essential ingredients for murder are unlawful act. It has to be an unlawful act. The act in itself has to be unlawful, which is to say, for example, if I pick up a gun and kill and shoot it at somebody, it is an unlawful act because I'm not allowed to shoot a gun in a public space, right? At somebody. Secondly, if there is an intention, a criminal intent or a malified intent to actually kill that person, that is an essential ingredient for murder, that whether there is an actual mens rea or malified intent to kill a person. The third is causation, right? Whether the act of the accused has directly caused the death of the victim, right? Which is to say, for example, I beat somebody up, but I beat him without any intention to kill, or say I beat him in a manner which is not likely to kill under ordinary circumstances, right? However, this person was taken to the hospital, and in the hospital, because of some mishap, say for example, this person ended up like mishap in terms of the drugs being given or the timely hospital service being given, this person ended up dying, right? Now, actually, the cause for the death of that person is actually not the killing itself, but rather the cause is the fact that some wrong drugs were given or the person ended up not getting timely treatment, right? So therefore, there has to be a direct causation with the act of the act by the act that the accused has committed, right? And the last, when there is an absence of legal justification. So there has to be an absence of legal justification for murder. Legal justifications can be a plethora of exemptions, general exemptions under the IPC, which include like pleas of insanity and such, or self-defense, which I'm sure a lot of you must have heard of, right? Now, there's a very thin line of difference between murder and culpable homicide amounting to murder. And that thin line of defense is generally has to do with the degree or the probability of death ensuing from the act in itself, right? And how does that manifest? We'll tell you subsequently, right? So whenever there is an intention to cause death, the offense will count as murder and not culpable homicide amounting to murder, right? Unless there are four exemptions given within section 300, right? Now, when there is, say for example, a grave and sudden provocation because of which somebody kills a person, then that can be considered to be culpable homicide not amounting to murder rather than murder, right? A recent Meghalaya High Court judgment I was reading the other day basically painted under this exemption. They included the fact that, say for example, there was this man who was accused of killing his wife's lover, and the court said that essentially it was under grave and sudden provocation because they caught them in a compromising position. He caught them in a compromising position in their bedroom, right? So therefore, there was grave and sudden provocation because of which there was death, because of which this man ended up killing this person, and hence it is criminal, it is actually not murder, but culpable homicide not amounting to murder. Similarly, exercising right of private defense in good faith, exercising duty as public servant for the advancement of public justice, and without any premeditation in the sudden heat of passion are things, and are exceptions under the law in which a particular killing will not be considered, a particular unlawful homicide will not be considered a culpable homicide, will not be considered murder, but rather culpable homicide not amounting to murder, right? Now, there is a very tricky provision here which says that where the person knows that the act they are committing is so imminently dangerous that in all probability it must cause death or bodily injury which leads to death, then this will be considered murder, right? And this is where I think if indeed in the future the police are to change the charge from 304 to 30, in fact to 300, just in order to go ahead and try this child as an adult, then this is what we need to keep in mind, because whether the person here, in this case the minor, actually knows that the act that they're doing, which is rash driving under the influence, is so imminently dangerous that in all probability, in all likelihood, it will result in the death of some person, is a question that we need to keep in mind and answer for ourselves to know whether, if indeed in the future they are to try this child, want to try this child as an adult, and therefore want to change the charge to say murder, then this is something that we actually need to keep in mind moving forward, right? This consideration is something that we need to keep in mind. Now, this is not never a straightforward, straight-jacketed formula as to where, in what case there is culpable homicide not amounting to murder, and in what case there is murder, right? And therefore, the question of intention, of motive, of criminal intention, of malified intention is always to be considered as a matter of fact, right? Now, 304A, which is what the boy was initially charged with, right? Now, that talks about criminal rashness. Now, criminal rashness, that causing death because of some negligent or rash act, right? Now, criminal rashness is a dangerous and a wanton act, and there is knowledge that that act might cause injury, but there is no intention to cause injury, right? That there is knowledge that this might cause injury, but there is no intention to cause injury. Therefore, the criminality lies in running the risk of doing such an act with recklessness or indifference as to its consequences, that is, without the belief in the result of such doing, that without the belief that actually someone might be killed, that actually the fact that a person will die, knowing that without the belief that the person might die, if I go ahead and act in this rash manner, right? So you know that it may cause injury, but there's no intention to actually cause injury or to kill somebody, right? Now, so therefore, a rash act is primarily an overhastly act and is opposed to a deliberate act. Even if it is a partly deliberate act, it is done without due thought and action, which means that there has to be some form of due thought. And when there is no due thought behind an act, and it is just, then it is considered to be a rash act. And even if the consequence of such rash act eventually is the death of a person, it comes under 304A, which is causing death by negligence, instead of actually 304, which is culpable homicide not amounting to murder, right? So therefore, the question we need to ask ourselves is, was there an intention on part of the minor in the Pune case to actually cause injury or death, right? And in all likelihood, the answer is no, because because the boy did not have enough due thought behind before going ahead and actually driving that vehicle, because he was already under severe influence and just wanted to get the thrill of driving this car rashly. Now, how do we understand the types of offenses under the JJ Act, right? Now, there are three types of offenses: petty offenses, which has a minimum punishment of less than 3 years; serious offenses, for which the maximum imprisonment. There are two kinds of serious offenses. In both cases, they are called serious offenses. Now, one kind of cases is where the minimum sentence of that offense is prescribed, and it is it is more than 3 years of imprisonment, right? However, there are lots of crimes in the IPC where there is no minimum sentence, but the maximum sentence is more than 7 years. Now, in a landmark judgment, Shilpa Mittal versus NCT of Delhi, the Supreme Court actually came up with this reasoning that when there is no minimum sentencing, but the maximum sentence is above 7 years, including life sentence, the maximum sentence can also be life sentence, then in those cases, it will be considered to be a serious offense rather than a heinous offense, because a heinous offense has to statutorily include more than 7 years of minimum imprisonment for that as a sentence for that particular offense, right? And this Shilpa Mittal, the court's verdict in the Shilpa Mittal case was then in the subsequent year in 2021 was actually imbibed by the legislature, and they ended up amending the act to reflect this change, right? Now, under Section 15 of the JJ Act, when there is a 16 to 18-year-old who has been accused of committing a heinous offense, an offense that has more than 7 years of minimum imprisonment, then the child, then the JJB, the Juvenile Justice Board, is supposed to conduct a preliminary assessment, and if the JJB finds that there is adult-like maturity in this child from the preliminary assessment report, and this preliminary assessment is conducted by an expert. Now, if after the expert conducts a preliminary assessment and the JJB finds by the report that the child has adult-like maturity, then they can be actually tried as an adult. Now, what are the elements of preliminary assessment? Firstly, there has to be heinous offense. Child must be above the age of 16. Then the preliminary assessment is conducted on the basis of 3 criteria, and all these 3 criteria have to be read together, right, inclusively. Firstly, whether there is a physical capacity or mental capacity to commit such an offense. Second, whether the child understands the consequences of such an offense. And last but not the least, whether the circumstances in which he or she committed the particular offense, what were they, right? Now, after considering all of them holistically, all 3 criteria holistically, the court comes to a decision whether the JJB comes to a decision whether the child needs to be transferred to be tried as an adult to the children's court, or they can be the JJB can continue dealing with the child, conduct an inquiry and sentence the child just as they would do to any other child who has committed a particular offense, right? Now, as I mentioned, that the board has to take the experience, has to take the assistance of expert psychologists and psychosocial workers when they are, or other experts who have experience of working with the child when they are conducting such preliminary assessment, right? Now, in this landmark case in 2022, Barun Chandra Thakur versus Master Bolu, which Sheila alluded to earlier, the Ryan International School case, the Supreme Court of India actually recommended SAMVAD-NIMHANS' assessment performer to be used while conducting preliminary assessment, right? And the court provided a very nuanced evaluative criteria under Section 15. Like for all these 3 evaluative criteria, the court provided a very nuanced understanding, right? Now, firstly, on the mental capacity itself, the court actually acknowledged that what Sheila was saying, that the very fact that the cognitive abilities of an adolescent and rates, wherein the social emotional competency cognitive control part of the brain is something that the court acknowledged, right? And therefore, they highlighted that the fact that just because a child might have intellectual insight or if they are unable to regulate emotions effectively, then they might end up doing things which their intellect does not warrant. Similarly, on the criteria of ability to understand consequences of the offense, Ms. I would just request you to mute yourself if possible. Thank you so much. The court emphasized on the need to consider consequences in the plural sense, which means that a longitudinal understanding of consequences, which means that multiple consequences have to be considered, and not just whether the child knows what the consequences are to the victim and to the victim, and also to the victim and the family of the victim, right? Or what immediately will happen to the child if they commit such an offense. So what the court highlighted, that consequences should be far-reaching, right? Which means that what is the consequence on the child in the long run, including the psychological consequences on the child? What are the consequences on the child's family, right? What are the consequences of the child's family? What kind of social stigma that the child will actually, and the family members of the child will actually incur because of them committing this offense? What are the consequences of incarceration? How will they deal with remorse and repentance for life? Are things all equally important consequences that the child must be able to understand for the JJB to actually transfer this particular child, right? And court actually very interestingly provided the very example which we are discussing today, right? Which is to say that the court said that risky driving may result in an accident, but if emotional competence is not high, the urge for thrill seeking may get better of the child's intellectual understanding, right? Which is something directly which relates to what we are discussing now today in this case, in the Pune case, right? Lastly, on circumstances, the circumstances also have to be longitudinal, which means that they have to be not just immediate circumstances in which the offense was committed, but also what Sheila alluded to earlier. What are the mental health issues like stress, deprivation, adverse peer influence, which the child was dealing with for a long time, history of abuse, history of violence in the family, history of substance abuse and drug and alcohol use in the family. All of this actually comes into assessing the circumstances in which the alleged offense was committed, right? Therefore, why are we actually discussing preliminary assessment and transfer? Right? Because the police actually has actually requested the JJB to allow to actually try the child as an adult, or allow them to try the child as an adult. But from whatever we discussed right now, we need to be clear of a few things, right? Understand that the sentence for committing the offense of murder is life imprisonment or death penalty, which means that it is a heinous offense, right? But culpable homicide not amounting to murder, which the child was subsequently charged with and is currently the highest charge that the child faces, actually has the punishment of life imprisonment or sentence imprisonment up to 10 years. There is no minimum sentence prescribed here, right? Which means that this is actually a serious offense and not a heinous offense itself. And hence, the child in no circumstance can actually be tried. But this is what public apathy has done to the police, that they are under so much pressure that they want to try this child as an adult, even if that means breaking the law in order to do that, right? Now the maximum sentence for, now let's understand if what happens if this was actually what the child was initially charged with, right? Which is causing death by negligence. Now, for that, the maximum punishment is 2 years with or without fine, which means that it was actually a petty offense and not really a serious offense under the JJ Act. And therefore, the consequences for the child would have been much different compared to what it is right now for him, because he's charged with 304, which is culpable homicide not amounting to murder, right? But as we can see that whether this was actually an act where this child had the intention of killing somebody when he was consuming alcohol and then subsequently driving the car rashly driving the car under influence, is a huge question that we need to consider, right? That whether such a child who is under influence, who has in all likelihood very little emotive control over emotional regulation, and has very little cognitive control over the thrill-seeking behavior or the thrill-seeking need, the thrill-seeking need that he has at that state, is somebody whether he actually had the intention of going ahead and killing somebody when he actually started driving the car, right? So these are certain emergent questions that we are left with. What offense should the minor be charged with? What is the nature of this offense? And lastly, what is the subsequent implication for transfer of the minor to be tried as an adult under Section 15 of the JJ Act? Right? Now, we'll quickly provide a brief glimpse of the JJ Act and how all of the things that we discussed till now about how rehabilitation and reformation should outweigh, the considerations of rehabilitation and reformation should outweigh that of retribution, is something that the JJ Act actually encapsulates in its entirety, right? Now, maybe minus Section 15. Now, what are the aims and objectives of the JJ Act? They are all to do with the fact that the child's basic proper care, protection, development, treatment, and social reintegration are of the paramount importance. And therefore, a child-friendly approach to decision-making, judicial decision-making has to be taken. And the main objective of the Act has to be to facilitate rehabilitation of children through processes and institutions that are present under the JJ Act, right? Now, what are the guiding principles of the JJ Act? Now, the Section 3 is very interesting, and it is unlike any other law in this country, particularly when it comes to criminal adjudication, is that the Section 3 provides a set of 16 guiding principles which have to be read with every provision of the JJ Act when it applies to children by all decision makers, which means that these are guiding principles which have to be observed by the police who is engaging with the child, by the JJB who is engaging with the child, by experts like yourself who might engage with the child, and by child protection functionaries like DCPO functionaries who are engaging with the child, and CCI staff who are engaging with the child. Let's say all decision makers have to abide by these guiding principles when they are engaging with the child, right? Now, these are the list of 16 guiding principles. We'll be considering a few which are relevant in this case, right? Firstly is the principle of equality and non-discrimination. A child cannot be denied equality of access, opportunity, and very importantly, treatment, no matter what their socioeconomic status is, right? Because they cannot be discriminated on any ground, including socioeconomic status. Now, therefore, we need to answer a question: can children from high socioeconomic status actually be vulnerable? We discussed earlier, Sheila discussed earlier that they can, and there are pertinent vulnerabilities which these children have to deal with. And if yes, then do they have the right to access treatment and rehabilitation for the same? The JJ Act very clearly says that they do, right? Now, the presumption of innocence is the second one that I wanted to discuss. Now, understand that ordinary criminal law has basically crimes which have two components. There is actus reus, which is a deliberate voluntary act or omission that results in the crime. Say, for example, in the example I gave of like shooting a particular gun is the actus reus. And mens rea, which is the mental element of the crime, which is the malified or criminal intent, right? Now, unless specifically mentioned, both actus reus and mens rea have to be present for a person to be convicted of committing a particular offense, right? Now, however, very interestingly, under the JJ Act, the Section 3 under the JJ Act, under the principle of presumption of innocence spelled out in the JJ Act, a person under the age of 18 is presumed to be innocent of any malified intent, which means that the JJ Act does not say that, the JJ Act does not even believe that children have the capacity to form such malified or criminal intent which is required for them to actually commit an offense, right? To be actually commit a crime. And therefore, the justification, that is one of the major justifications as to why they are not tried as adults, but there is a separate form of separate system of adjudication which applies to them, right? Therefore, we need to ask ourselves, did the public's and the system's reaction to the incident undermine the child's right to be presumed innocent when these news channels went ahead and these news reports went ahead and kept calling this child a super brat, a murderer, right? When everyone was outraged and wanted to like give the strictest of punishment to this child, did we actually forget the fact that the JJ Act actually presumes that all children no children has the capacity, the mental capacity to form criminal intent, which is essential for actually for a crime to for them to commit a crime and then be called criminals in the first place. And hence we don't call a child a child who has offended a criminal, we call them children in conflict with the law, right? The next principle is the privacy and confidentiality principle, and related to it, the principle of fresh start. Nothing, no identifying marker of the child can be revealed in the media. However, we do know the name of the father because every report in the media has run with the name of the father, right? Therefore, that is something that Section 74 of the JJ Act actually prohibits, but that's something which has happened. And hence, we need to ask ourselves, and the reason why privacy is so important is because once a child goes through the JJ system, the record of the crime is not kept, right? And hence, if indeed in public domain the name of the father, the act of the child, videotapes of the CCTV footage of the child where his eyes are blackened out but his whole face is visible, when all of this is available in public domain for eternity, at that point in time, how will the child actually be getting a fresh start, which the JJ Act ensures has to be provided to every child who has committed an offense, right? And hence, when media reports did all of this, we need to ask ourselves whether the right to privacy for the child and the principle of fresh start that we have to give the child is something that was severely compromised with. Similarly, principle of positive measures and responsibility and repatriation. Now, principle of positive measures is that all measures should actually be taken to reduce the vulnerabilities of the child. But when we know that the family system is so volatile, when we know, and even if we don't know, we should wait for the social investigation report to actually tell us. The JJB should have waited for the social investigation report to tell them what the scenario with the family is, right? If that is the source of his vulnerabilities. And indeed, if it is, then at that point in time, like what is the principle, like at that point in time, should he actually be sent back on bail initially to the family is something that we need to really ask ourselves, right? Because although the JJ Act says that the primary responsibility of care, nurturance, and protection of the child lies with the biological family, it is not always the case, right? And therefore, we have childcare institutions because of the revolving door phenomenon. Is that if the cause of the vulnerability is the family itself, then if we send the child back to that family, then it is likely that the child will be re-victimized and re-enter the same JJB system. They'll commit more offenses, and they will actually become even more vulnerable. The vulnerabilities will be compounded, and hence the JJB's decision to initially release the child on bail in such quick time seems seriously questionable because of the fact that because in all likelihood it was not a positive measure that dealt with the vulnerability of the child, right? Last but not the least, we'll discuss the principle of best interest of the child. All decisions regarding the child shall be on the primary consideration that they are in the best interest of the child and to help the child to develop full potential. And therefore, was the JJB's initial decision to release the child on bail in his best interest? The answer in all likelihood is no, because the child is returning to the place where the source of his vulnerability. Was the JJB's subsequent decision to cancel bail in his best interest? Again, we need to ask ourselves that whether the JJB, when they cancel bail, whether it is when they're keeping this child away from the family, whether it is in their best interest. In all likelihood, maybe in this case, yes, but we are not aware of what the social investigation report actually says, because that cannot be made public, right? Was the police adding the charge of culpable homicide not amounting to murder after the initial public outcry in his best interest, or whether it is actually done just to satiate the need of the urge, the thirst for retribution that the public had? And was the police pleading for the child to be tried as an adult in his best interest, right? Now, especially when this is something that the law prohibits for crimes such as these. So who can be held accountable? As Sheila already mentioned, as Sir mentioned, we are not advocating for the child to not be accountable, right? But it is not just the child. There are multiple actors here who can be held accountable, including the child. And let us see how the JJ Act actually can help hold people accountable, right? The family can be held accountable because Section 75 of the JJ Act describes cruelty to children. And when there is willful neglect of a child, allowing them to spend 64,000 in a pub, allowing them to drink till 2 a.m. in the morning and then drive the second fastest electric car in the world without a license, then this amounts to willful neglect, and the family members can be punished for, and this punishment can extend to 3 years and a fine of up to rupees 1 lakh, right? Section 77 of the JJ Act, whenever someone gives alcohol to a child or any other drug, or causes to be given, which is to say, if they give money, which is spent by the child to buy that alcohol, that is also can be considered that they are causing the child to be given alcohol. And that time the sentence can be extended to 7 years, and subsequently a fine of up to 1 lakh rupees can also be charged. Similarly, Section 180 of the Motor Vehicle Act also goes ahead and can hold the family accountable, right? Can the bar owners and managers who have failed in this case also be held accountable? Yes, Section 77, as we discussed earlier, giving a child alcohol is a crime. There, and also state excise laws of respective states also determine the penalty of serving alcohol to minors, right? Now, can the system be held accountable? The system can and has to be held accountable. And in fact, a committee has been set up by the government to actually probe the initial bail order that the JGB gave. Why did they give such an order? And appointment of any JGB member under Section 4 of the Act can be terminated after holding an inquiry by the state government if they are found guilty of misuse of power that they are bestowed by the JJ Act, right? Similarly, Chapter 9 of the IPC talks extensively covers a number of offenses related to false evidence, which the doctors here facilitated. And these are on your screen here, and especially the fact that taking money to actually provide false evidence is severely punished under the law, right? Now, last but not the least, can the child be held accountable? Yes, he can and he should be held accountable. But how should he be held accountable? And there's a spectrum, right? On one hand, we have extreme leniency. On the other, we have extreme retribution. The JJ Act advocates for a place in between, right? And how does the JJ Act does it? Firstly, what are the kinds of orders that the JJB can pass? There is a plethora of orders. There's a whole range of orders that the JJB can pass with regards to a child, right? Which is to say, they can send a child to a special home, or a place of safety for up to 3 years. They can order community service, group counseling. They can order the parents to pay fine. They can provide reformative services, including education, counseling, behavioral medication modification therapy, which I'm pretty sure all of you are very well aware of, and psychiatric support during the stay at the place of safety or special home. They can also go ahead and order to attend a therapeutic center, an external therapeutic center, the likes of tertiary hospitals across the state, or also undergo de-addiction program, which is extremely pertinent in this case, right? Similarly, the Section 8 of the Act also talks about the fact that the JJB has the responsibility of forming an individual care plan for the rehabilitation of the child, including creating a schedule for DCPU in terms of how they should follow up with regards to the progress that is made by the child on their rehabilitation and reformation front, is something that the JJB can actually go ahead and stress upon. And hence, the child can be held accountable. I think just to conclude what we just discussed, is the fact that accountability is a very tricky metric, right? And as Shanta Sinha, who is the first chairperson of the NCPCR, once very recently said, that every child in conflict with the law is actually indicative of the fact that the system is also in conflict with the law, right? Because the system has failed, because of multiple stakeholders in the system has failed, including family members, right, have failed, is why a child comes in conflict with the law. And therefore, accountability cannot be considered with such a myopic lens, and we have to broaden the scope of accountability and also make it as reformative and rehabilitative as we can for the child in question. Thank you so much. Sheila and Sir, if you'd like to take it from here.
Yeah, thank you very much, Shubham. As you were talking, there have been certain comments that have been posted on chat. Some I have responded to, some Sheila has also responded to. But there are three that I would like to take up. Let's take the issue which both Krishna and Ruma have alluded to on chat. This is about this. Is a 17-year-old really a child or an adult, and can an 18-year-old really be considered to be quote innocent unquote. And Sheila had put on chat the whole issue of neurodevelopment, and I like to sort of return to this issue and say to you, friends, maturity is not a birth date. It's not that at 17 years, 364 days, you're stupid and you have your birthday party and after midnight, you sort of magically turn into a mature adult. Remember what we said at the start of the session. Neurodevelopment, particularly synaptic pruning and myelination, continues till the age of 24, 25. So your brakes and accelerator, the cognitive systems and the emotional systems develop at different phases, and they are not in sync. And neurodevelopment has informed law, it has informed policy. And therefore, as mental health professionals who are concerned with the predicament of children who come into conflict with authority, who come into conflict with law, we have an obligation to use science and use scholarship and our scientific sagacity to really deal with this issue and not function with the reaction of which it becomes strident. But there are a couple of other issues that have come up, and I will request Shubham also to contribute to this. One came from Sushil Sompar, and Shubham, you've alluded to this in terms of parent responsibility. Can parents be held responsible? And can parents be held responsible for abetment? And many people have told me when I spoke about this incident and the fact that opinions are getting polarized, many people have told me, so everybody's going to go scot-free, is it? And no one is responsible for the death of these two people. So everything is hunky-dory and you're going to... So we said that, remember what we are saying, even this adolescent has to be accountable, but not in the adult criminal justice. There is enough provision. And remember the slide that Shubham presented, extreme leniency on the one hand and extreme retributive approaches on the other, none of which have been shown in literature and science to be effective. The JJ Act is a good act and we have enough provisions to manage this. But Shubham did speak about certain legal provisions under which the parents can be held responsible. Shubham, would you care to sort of reiterate those?
Yeah. So the parents in this case can be held accountable, as I already mentioned, Section 75 and 77 of the JJ Act. 75 includes cruelty to a child. There are multiple different acts which are described as being cruel to a child, right? And in this case, what the police has charged the father with is Section 75, which is cruelty to the child by the form of willful neglect. The very fact that the child was allowed to go to a pub and be drinking at a pub till 2 a.m. at night, given 64,000 rupees and probably more, that's just the bill, but probably more, and then allowed to drive without license, the second fastest electric car in the world, is indicative of willful neglect. And therefore, the police actually charged him with willful under cruelty under Section 75. Similarly, 77, which says that giving a child alcohol or other drugs or causing to give the child. Now, giving is directly giving the child, which the club owner, the bartender, whatever bar manager did, right? Now, causing to give is when you provide certain resources to a child which can be used, because the resources can be used without supervision, can be used to go ahead and do such things like buying alcohol, then even that can be considered under Section 77, which has a punishment of up to 7 years, because you're creating the circumstances under which the child might be given alcohol, right? So in this extent, the parents can be held accountable. With regards to abetment is a very different crime altogether. And abetment has to have a rational nexus with the act itself, right? which is to say that negligence is actually does not amount to abetment. When will it be abetment? Say, for example, if there are friends of the child, and these friends actually, after getting drunk, encourage the child to go ahead and drive rashly, right? At that point in time, that can be considered abetment, right? But in this case, it is in all likelihood that this is not, there is no reasonable rational nexus with the act in itself, with the parents' act of neglect and the act of the act which resulted in two people dying, right? So therefore, it won't be considered abetment.
I just
Thank
wanted
you.
to
Yes,
provide
Sheila,
a
go ahead.
quick response. I think Dr. Shirod Mishra says when voting age in our country is 18 years, is the Section 3 of the JJ Act relevant? And, you know, for an 18-year-old child. The
There is
issue
a
is,
preamble to that, Sheila, also, when he says the punishment is so soft, 6 months for rash driving, when he's not even eligible for driving license, and there is no fear of punishment, etc. So if you could put both these together, and perhaps you can respond in Shubham as well.
no, I actually wanted to respond more to the issue of voting. It's important to make a distinction between different activities or engagements that an adolescent or an older adolescent or a young person may have. There are what are known as hot cognitions and cold cognitions. Now, issues such as voting or providing consent in, let's say, medical procedures or research and other issues of that nature are usually done under parental supervision, or even if not that, they don't come with a huge time pressure. They're not necessarily done under peer pressure. This is very different from hot cognitions, which are to do with behaviors like drinking, driving, use of course, other substances, sexual activities, all these adventure sports, these so-called thrill-seeking activities and behaviors, which, you know, if you look at the nature of the activity and the kind of reward or gratification that an adolescent gets from it, there's an intense time pressure. These are usually activities that occur within peer groups, particularly amongst adolescents. So they are called hot cognitions. And the evidence shows that in areas of hot cognitions, you know, when it relates to activities such as these, that is where adolescents have the maximum trouble for obvious reasons. Because of issues, you know, their limitations of brain physiology, because of peer pressure and various other vulnerabilities, their difficulties with regulation. So what we are saying is the difficulty that adolescents have with decision making is not the same across the board. It's not a blanket decision-making ability. That is why you see adolescents making decisions differently in different scenarios. So, you know, in certain situations, it may appear that they can exhibit some level of maturity and thinking, and in others, it appears that they absolutely cannot. And it is in these thrill-seeking activities that they have trouble. So it's important to differentiate situationally between, you know, activities that adolescents you know, need to or that they choose to engage in. That's what I wanted to respond to. Maybe Shubham wants to
Just
respond
building
to
on what Sheila has already mentioned, I think just a couple of examples, right? Firstly, look at how you form relationships, sexual relationships, or the idea of sex and sexual relationships as a young person, not just somebody who's 17 or 18, but including somebody who's 19, 20 in college, say, for example. What are the considerations that the person has while actually forming a sexual relationship, as opposed to the same person forming such a relationship 10 years later when they are 30, 29, 31, right? At the age of 18, 17, 16, 19, this decision making is based on thrill, right? The very instant gratification that you receive from a sexual relationship or a romantic relationship for that matter as well. But whereas when it is 10 years later, you know, when you're 29 or 30, the considerations change, and you actually value things like safety, you actually value things like family, like whether the families are compatible or not, whether the socioeconomic status is compatible or not, and other plethora of other factors, right? Whether you're compatible in the long run or not. All of these becomes very important for you to engage in such a relationship, right? But when as a young person, that is not the case, and it's because it's precisely about the fact that instant gratification is what adolescents seek much more than adults, right? But secondly, moving on, I think there's this the very fact that rash driving is something which is prevalent amongst young people, not just adolescents, but young people up to the age of 24, 25, has been started to be recognized by multiple jurisdictions, including that of Tamil Nadu. And therefore, the Madras High Court has actually gone ahead and actually requested, and they've recognized the fact that adolescents don't do it because they have a criminal intent to go ahead and cause chaos by rash driving. They do it because they are unable to go ahead and control their impulse for risk taking, appetite for risk taking, and thrill seeking, right? And hence they want to actually create diversionary. The High Court wants to create diversionary measures for such young people who come in conflict with the law because of rash driving. They want to create diversionary measures so that we do not keep punishing them under the ordinary criminal justice system, because that does not lead to any form of reform or rehabilitation, right? So that's something that has been recognized by multiple jurisdictions, and the Madras High Court is actually trying to do something about it to divert these people, because they recognize it's not really a malified criminal intent because of which they do such an act.
Shubham, can you link what you said now with a comment that Colin has made, which is children in conflict with law with serious crimes having, they're not amenable to interventions, mental health interventions, and even the JJB are unsure and apprehensive what happens after the age of 18, since you've spoken about place of safety and diversion. And then I'll come back to a couple of issues on school, the role of the school raised by Shikha, and other issues raised by Ravikant Angela on both on systems as well as why families come into play. And I'll finally address Shirod Mishra's issue on the nature versus nurture thing and accountability where death actually takes place. And I think I would be able to throw some light and balance into the point that Dr. Mishra is raising. But the point
Can I
that Colin
just
is
jump
raising
in?
is what?
Yeah, can I jump in on Colin's point about
Please do, Sheila.
adolescents who have conduct disorder and are not amenable to interventions and so on? I think we are in deep waters here and on slightly tricky grounds. I think it's because in all of our experience, we've also found that the nature and quality of mental health interventions to address children and adolescents who have serious and severe behavioral issues has been relatively limited in our country. I think it's important to acknowledge this.
True.
Child psychiatry itself, child and adolescent psychiatry itself is in a state of infancy in India, although many strides and developments have been made, not nearly enough. There are relatively few child guidance centers across the country, few departments of psychiatry that really do specialized work in the area of children and adolescents. The kind of training programs, that is this specialized training programs on working with children and adolescents, not just with children in conflict with the law, but in many other specialized areas as they pertain to disability or child sexual abuse and a myriad others, are relatively few in our country. And that's why we have a serious paucity of knowledge and skills. And that's one of the reasons why we established SAMVAD. There is also the Department of Child Psychiatry at NIMHANS, and there are others like PGI Chandigarh and Tezpur who have departments of psychiatry that are running Doctor of Medicine programs in child psychiatry, but they are not enough. So I think we need to do a lot for ourselves to be able to upskill and upscale our efforts? The answer really lies there. So, issues like establishing therapeutic relationships, therapeutic alliance, having scientifically backed interventions for these children, these are the things that are going to play a huge role in what we are able to do in terms of reformation and so on. So I think we need more convergence on doing these training programs, and when they are conducted by agencies such as ours for tertiary care centers, secondary level mental health services like the district mental health programs, to proactively allow their staff to attend these programs. That's our only way forward. We're pretty much up against a wall where child mental health is concerned in our country. It is a ticking time bomb. We, every so often, when there is an incident of this nature, that's when, when things really explode, we come together and see it. And then, same thing happened with Nirbhaya, and then things sort of, unfortunately, move back and we lose momentum. That's the unfortunate part.
A quick thought,
Hoping that
Sheila,
we will.
on the role of the school that Shikha has
Yeah.
raised with
On the role of schools, I believe Kriti has put some links on our resources for life skills education. We do a lot of training of teachers as well. So on how to use some of these life skills, which I also alluded briefly to. So for a child like this, we would look at whether it's de-addiction and so on, but also to look at how this kid, for example, can contend with some of the exceedingly difficult family influences that he has had. Remember all the bits about legitimization and normalization of power and control-based systems that the family probably, I mean, I'm hazarding a guess, probably has been following. At least that's what seems evident. So how do we work with the child on issues of that nature? How do we equip the child on with skills on decision making, on problem solving, on making decisions about peers, about substance use? So a lot of this kind of content is what is available in our life skill resources, which is what schools should be using to do these kind of life skill sessions, which use creative methods like art and theater and film and so on, non-didactic methodologies to equip children with the skills they essentially need for life, not just in a given context today.
Thank you for that. Thank you for that.
Can I just
Suchita, Suchita, we will not be able to address the issue of the 35-year-old who sort of was in an accident and was asked to get into counseling and all that, because we don't know in which era it occurred and under which JJ Act dispensation. Perhaps we can take this discussion elsewhere. Shubham, anything about Ravikant's issue on the family has been kind of dealt with, but this business about is 18 too late and the 15 to 16 cutoff issue has been discussed actually where JJ Act is concerned, but not in the context of children in conflict with law, in the context of POCSO and other vulnerabilities. But Shubham, you have a thought on this point of Ravikant's on should 18 be the age of juvenility or should it be reduced? Do you have any thoughts on that?
So the cutoff age of like 18 is something which has a lot of different backgrounds and understanding and reasoning as to why it is 18, right? I think first of all, the very reason it is 18 is because universally, like the CRC prescribes the Convention on the Rights of the Child and the Beijing rules of earlier in 1985 as well, they prescribe the age to be 18, right? The reason why it is the case is because in majority of jurisdictions, we just believe that is the age at which a child turns from a child to an adult, right? Of course, we understood, and Sheila went on about it, and she very elaborately explained why overnight the child does not really become an adult. And the very fact that the reason why we have it is at 18 is just because of it is for administrative convenience, right? Nothing more, nothing less. It's an administrative convenience. Somewhere you have to draw the line, but a few jurisdictions in Europe particularly has actually started experimenting with increasing the age of juvenility, right? Which is to say that from 18 they have extended it to 21, in fact to 23 also in one Scandinavian country, I'm forgetting which one, but in Denmark, say for example, it has been extended up to the age of 21, right? So they are experimenting, and it's a very new development. It's not something which is old, and the developments have taken place because they recognize that the development of the neurodevelopment of a child continues till the early 20s, right, till the age of 25 in most age, like 24 or 25, and therefore they recognize that, and based on science they have taken this decision to actually increase the age of juvenility. But why it is 18? Just administrative convenience, right? There's no other reason as to why it is at 18, because it is arbitrary. We do understand it, but because of administrative convenience for most laws in this country, almost I'd say all laws in this country, it is uniformly set at 18, set at 18, right?
Thank you for that, Anupma. All our teacher training program, how to use the website is something that we'd be happy to discuss with you if you get in touch with us. Our links are there. And finally, Shiro, to come back to the point that you made, nature versus nurture, let me state this in conclusion. In the Pune Porsche case, did he know that one should not drive a vehicle without a license? Yes, he did. Did he know that you should not drive an unregistered vehicle? Yes, he did. Did he know that you should not drink and drive? Yes, he did. Did he know that he was going to kill a team of people? No, he did not. Did he intend to? No, he did not. So please understand, friends, that Dr. Mishra is raising a very serious issue here, but we need to make the distinction on the whole issue of intentionality. And therefore, when we look at extreme leniency on the one hand, and the kind of errors in judgment that has been made for a system, a legal system, which is actually robust and good, and then the kind of strident shouting for severe punishment and retribution, that there is a balanced approach we need to take. And of course, people have to account for what they did, and there is enough accountability in the JJ system. Therefore, we are geared towards the retention of people in the JJ system. We are in principle against the whole issue of transfer. And that is why, to state again, for those who have said that in the Barun Chandra Thakur versus Master Bholo judgment, the Honorable Supreme Court has not really issued guidelines, which I have heard recently. This is not the case. In fact, they have recommended that the approach that we have worked out is something that we need to do, because we look at a robust social investigating report, even for the people in privileged circumstances, to really look at how we assess and assist in the principles of restorative practice. I've also noticed some other comments. As a mental health professional, how do we protect our objectivity? Indeed, a crime is a crime. And not having common sense intent while being restless is a lesser crime. Ravikant, we need to discuss this in more detail. Please, there are legal and mental health implications which we have discussed in detail in this session. And there is a legal issue because mens rea is important. And we need that harm has occurred, and in fact, the whole issue of victim impact and the whole principle of restorative practice is the acknowledgement that harm has been caused, and what you do in terms of addressing that. This is the principle of reconciliation psychology. I would be happy to discuss with this. And yes, Ruma, victim impact, the issue of there are legal aspects to that which we will have to get into, not within the purview of the discussion today. We are happy that many of you have stayed on and attended this session. Thank you very much for your attention and your active participation. And with that, we will close the session. And since the issues is active, perhaps we will do a follow-up session to address many issues that you'd still like to debate. We may not do it as a presentation. We may do it as an open session, as a discussion session, and so on. Thank you very much. Thank you, Shirod, for your appreciation. Thank you, Colin, as well, and everyone else who are putting their positive comments on chat. And with that, we bid you all a good night from Samvad. Thank you.